Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2.
We've got 6 total, correct?
5.
5.
Yeah, so it's you know how to do this. One of these?
Not.
This can go anywhere. Pocket. Most bands just put it in a pocket. Got a belt clip if you really want. And just test those. So we could each just say a word or two or your name. Got to turn them on.
Testing, 1, 2.
Okay.
Testing.
Matt, I'm here.
Yep. The little green lights are on, right? Sounds like it.
It's okay for us to turn, like, I'm going second.
I have you muted. So, you're going to be mumbling to yourself or something. You want to make absolutely sure that.
I have no idea.
Please be seated. Good morning.
Morning, everyone.
We are here in the matter of in re Catherine Connors. I wanted to let council know the panel has reviewed all of the submissions, all of the filings, and you can obviously tailor your comments given that information. I understand that the committee has reserved 10 minutes for rebuttal. Is that right?
Yes,
Okay. I don't know if either side will be anywhere near their hour limit, but that is obviously the limit. All right, with that, arguments.
Good morning. My name is John A. McCardle III. I'm counsel for the Committee on Judicial Conduct, and I also wish a good morning to everybody in the courtroom and Attorney Bowie and people who are watching and or listening to this proceeding. The Committee on Judicial Conduct was established by the Maine Supreme Court in 1978 to independently investigate alleged violations of the Maine Code of Judicial Conduct. The committee receives, processes, and investigates complaints concerning any judicial officer, be they on the Maine Supreme Court, the Superior Court, the State District Court, or any of the Maine probate courts. The committee consists of 8 voting members, which includes 3 judicial voting members, 2 attorney voting members, 3 public voting members, as well as 5 alternate members. In this case, Attorney Thomas Cox filed a complaint against Maine Supreme Court Associate Justice Catherine Connors with the committee in January of 2024. In essence, Attorney Cox complained that Justice Connors violated Rule 2.11a of the Code of Judicial Conduct by failing to recuse herself in the case of Finch versus U.S. Bank, and by continuing her involvement in the companion case of J.P. Morgan Chase Acquisition Corp. Versus Camille J. Moulton. Both cases were appeals to the Maine Supreme Judicial Court. Code of Judicial Conduct Rule 2.11a requires that a judge shall disqualify or recuse himself or herself from any proceeding in which the judge's impartiality may be reasonably questioned. After receipt of Attorney Cox's complaint and review of the materials provided to and obtained by the committee requested that Justice Connors explain why she did not recuse herself from the Finch and Moulton appeals. Following Justice Connors' initial letter response to the committee made additional inquiry of Justice Connors regarding the committee's concerns and questions. With Justice Connors' original letter were emails back and forth, one to the Judicial Ethics Advisory Committee from Justice Connors and a response to her from that committee. After evaluating information obtained, the committee found that Justice Connors violated Canon 2, Rule 2.11a of the Code of Judicial Conduct and recommended that she receive a public reprimand. Ordinarily, when there's a complaint against a Maine state court judge or justice, the Committee on Judicial Conduct and the committee finds that conduct is serious enough to warrant some kind of sanction against the judge. The matter is referred to the Supreme Judicial Court for review and final determination of the matter. In this case, because the matter involves the question of the appearance of impropriety and it is brought against a member of the Maine Supreme Judicial Court, the Committee on Judicial Conduct suggested to the Maine Supreme Judicial Court that it would be best that if the Maine Supreme Judicial Court did not evaluate and decide a matter involving one of its own. The committee thought this suggestion particularly appropriate because the complaint of Attorney Cox, which the committee found to be meritorious and warranting a sanction against Justice Connors, involves the appearance of impropriety. Thus, the committee thought that if the Maine Supreme Judicial Court members were to pass judgment on one of their own colleagues, that scenario could raise a question about the impartiality of the judges who were judging one of their colleagues, and at the very least create the impression of the appearance of impropriety. Subsequently, 2 members of the Maine Supreme Judicial Court recused themselves from this matter, and then the Maine Supreme Judicial Court as a whole decided not to hear the matter, instead appointing a hearing master and then this panel to review and evaluate and determine the outcome of the complaint. From the Committee on Judicial Conduct's point of view, the question to be answered here is, would an average person, knowing all the facts presented, reasonably question Judge Connor's impartiality? And to help answer that question, we need to know who is the average person. And case law tells us that the average person is the person on the street. It's not, doesn't have to be a lawyer, it doesn't have to be a judge. What are all of the facts that the reasonable person has to consider? Well, that means all the facts, not just a few facts, not just one-sided facts, all of the facts. Facts that are known to the judge whose impartiality is being questioned, that may not be known to other people, and facts that are known to other people, including perhaps the judge. Before getting into the rule and the analysis of the rule and application of the rule.
May I ask a question?
Go
I
ahead.
had 5 minutes of uninterrupted, but
Sure.
does the average person, does one of the facts that the average person considers the fact that Justice Connors went to an advisory committee of other judges, and I presumably, as I understand, that committee also consists of a member of the public and a lawyer. But does the average person get to know, or should the average person consider that the justice actually sought advice as to whether or not she needed to recuse and was told she didn't have to?
I think that it's only fair that that is part of the factual matrix, or one of the facts that's pertinent to the analysis of this entire proceeding. And although I'm not there right now, I will get to the committee's view on what was presented to the Judicial Ethics Advisory Committee and why the opinion that they rendered did not have all of the facts, but the fact that that information was sought, when it was sought, what information was provided to that committee, and the committee's analysis are all facts that the committee would say is fair for this panel to consider. And I'm happy to address any concerns at any point that any members of this panel have about the committee's view of what happened and what didn't happen in that regard. Before getting to the analysis, I want to go through some of the facts that the committee thinks are salient ones to just understand the background and what happened without walking through every fact there is. Mindful that this panel has reviewed the substantial documentation in the case, and we're not trying to repeat everything here and take up more of the panel's time than is necessary. But some of the real basic facts that are important to consider are that before Justice Connors became an Associate Justice on the Maine Supreme Court, she practiced law for 34 years, primarily as an appellate attorney at the firm of Pierce Atwood in Portland. She represented various clients in many areas of law, including various banks, the Maine Bankers Association, the National Mortgage Bankers Association, and appeals relating to banking issues, including foreclosure cases. And her work for banks started as early as the early 90s, I think 1993. Pierce Atwood, where Justice Connors was a partner, was and is an affiliate member of the Maine Bankers Association. And Justice Connors, in her second letter to the Maine Committee on Judicial Conduct, when asking about her conduct, indicated that she had represented various banking interests for many years, advocating for them in litigation. The committee cited a handful of cases for which Justice Connors had participated as a writer of briefing to the Maine Supreme Court on behalf of banks or banking interests. But more on point and sort of central to the analysis from the point of view of the Committee on Judicial Conduct is that Justice Connors, in the case of Pushard versus Bank of America, a 2017 case, a foreclosure case before the Maine Supreme Judicial Court, Attorney Connors was one of two attorneys that wrote, signed, and filed the brief on behalf of the Bank of America.
Mr. McCardle, should we accept that the reasonable person understands that all judges in Maine have experience and expertise in one or more areas of law before they become a judge?
Yes, absolutely. And in Attorney Connors' case, when she was testifying before the Joint Standing Committee of the Judiciary at her confirmation hearing, as the panel knows, there was a fair amount of questioning of her about specific areas of law in which she focused her practice, including and particular clients of hers. And part of the questioning from the chair of that committee and a representative of Evangelos and a representative named Hartnett concerned their concern about her past representation of banks and representation of banks and banking interests in foreclosure issues regarding foreclosure matters and foreclosure cases. And Justice Connors, in response to the expressed concerns of those legislators said, with respect to foreclosure cases, she expected significant recusals.
But wasn't that true? I mean, for 2 years, she stayed away from any case involving Pierce Atwood, and didn't, I think she stayed away from foreclosure cases for that similar period of time as well.
Well, interesting.
So, what is meant by significant recusals, if in fact, how long does it go on, I guess my question is?
That's a good question. Let's talk about a few of the things that she said at the confirmation hearing. I believe she said that if a case involved a client of hers for which she had worked on the case, that she would be either recused for the length of her term, which is 7 years,
right,
or for life. She said that if it was a case involving a client like Central Maine Power, or a case involving tribal rights in Maine, where she had taken positions on behalf of clients against the tribal nations, she would be recused from those cases for life. She said, with respect to foreclosure cases, she expected that there would be significant recusals, and I think she implied that she would be recusing for the length of her first judicial term, which is 7 years. There was nothing ever said, I'm going to recuse for only 2 years, or I'm going to recuse for only 1 year or 3 years. And the first time that this notion that she was planning, that she did recuse or was going to recuse for 2 years, that only came up when she was responding to the Committee on Judicial Conduct after we had contacted her about the concern that she had participated in both the Finch and Moulton cases. So it's not entirely clear what significant recusals meant to Justice Connors in her mind, and I don't know what this panel thinks is significant.
Having been
but
through
2 years
those-
is not significant from the committee's point
Sure,
of view.
I understand. But having been through those confirmation hearings, all of us have been, they may not be fact-specific. You may be responding to a question from a legislator in a general sense, and you really haven't focused in on a particular factual scenario that's been presented to you. I don't know whether Justice Connors, during her confirmation hearing, ever said she would never participate in a foreclosure case. She did say that she expected significant recusals, particularly given the fact that she had worked for Pierce Atwood for, 34 years, you said?
34 years, yeah.
34 years, so, and so there were significant recusals. But is it your position, or is it the committee's position, that she made a promise to the committee that she would never be involved in a foreclosure case, at least for her 7-year term?
The committee's position and view on this is that taken in the context of recusals for life, recusals for the term of 7 years, and the statement that with respect to foreclosure cases there would be significant recusals, means more than a period of 2 years, and particularly, not talking just about foreclosures generically. In this particular case, what's striking about the case is that the appeals that Justice Connors was going to consider were appeals that were specifically thought by the Main Judicial Court to be potentially overruling the 2 specific appeals she had worked on, the DeShane case and the Pushart case. So what's striking about this case is that Justice Connors worked for the banks and banking interest on those 2 appeals. Then, and she goes to a confirmation hearing, and at the very least, she's aware that legislatures are concerned about her past work for banks, including foreclosure cases, and questioning her about necessary recusals in the appearance of impropriety in those types of matters. Then what happens is those appeals go forward, and she participates in the Finch appeal in June and doesn't even consult with the Judicial Ethics Committee until September. So instead of getting advice from the Ethics Committee and then taking that advice and either doing what they suggest or not, she plunges ahead, participates in the oral argument in Finch, and 3 months go by before she even contacts the Ethics Committee. And at that point, she contacts them in a manner where she doesn't ask for a formal opinion, she asks for an informal opinion. So this is a case where the connection between Justice Connors' involvement in 2 appeals as a practicing attorney, and then being involved in 2 cases that are potentially overturning those 2 cases, and in terms of potentially overturning those 2 cases, in August, after in August, about a month before Justice Connors contacts the Ethics Committee, the law court sends a notice out soliciting briefs, specifically stating that the appeals that are being reviewed and the question being considered is whether the law in Pushard should be overturned. So Justice Connors knew these were foreclosure cases. She knew what the issues were. She knew she participated in the appeals court argument before she even contacted the Ethics Committee. She knew that the appeals to be decided would either uphold or reject and reverse the law that was controlling, that she had fought on behalf of the banks before and lost.
But Mr. McCown, may I ask you, I guess what I'm trying to get at is a lawyer who may zealously advocate for a position while a lawyer, whatever position that is, loses the case, or wins the case for that matter, it really doesn't really matter, but advocates for a certain position, then gets on the court. In this particular case happens to be the SJC, but it could be any court. And the issue that the attorney advocated for as a lawyer comes up before him or her as a judge. What I'm trying to get at is, are we imputing some impartiality to a lawyer because of the position the lawyer took for a client in an unrelated case? I understand the issues are similar, but it's an unrelated case where the client is not involved. Are we imputing and saying, well, the public has to impute some level of partiality to that attorney because that attorney must be biased because he or she advocated for a position for a client in an unrelated case? Is that a fair thing to do, to impute that type of bias to someone, to a lawyer? Because that's the connection. I mean, it may not be actual bias, but
let me try to answer that question the way I understand it. And you can correct me, of course, if I don't understand the question or I haven't addressed your question sufficiently with my response. The issue is not whether a judge is biased or is actually impartial. The issue is whether a reasonable person would believe, or rather question, it doesn't have to be proven, a reasonable person would question whether the judge is impartial based on all of the facts and circumstances that are known about the situation. And that's a much lower hurdle or an easier thing to show or imply than showing a judge's bias. That's why there's a separate rule for the appearance of impropriety, because the appearance of impropriety is really based on the premise and notion that to do justice, justice must appear like justice. And for example, one of the cases that I cited was a Massachusetts case involving a federal judge, Nancy Gertner, a very well-respected jurist in Massachusetts. And an issue came up, and her impartiality was questioned because she had made a statement to the press saying that a particular case that she was involved in was more complex than a similar case that had come up before. Now, that seems like a pretty innocuous comment, and it is an innocuous comment, but the panel, one of the parties sought disqualification of Justice Gertner, and a panel of judges on the appeals court for the First Circuit looked into the matter and decided it. One of the judges on that panel was Kermit Lopez, who we know was a Superior Court judge in Maine, was a judge on the Maine Supreme Judicial Court, then went to the federal court, Federal Appeals Court, and the panel, considering Justice Gertner's conduct, said, among other things, that when the facts provide an objective, knowledgeable member of the public a reasonable basis for doubting the judge's impartiality, the judge should recuse. And if the question for requiring disqualification is a close one, that tips in favor of recusal. The court stressed that Judge Gertner wasn't actually biased or prejudiced, but regardless of the judge's actual impartiality, a reasonable person could perceive bias to exist, and that cannot be permitted. And the court said, the court, to perform its high function in the best way, justice must satisfy the appearance of justice. So it's not a matter of whether the judge is in fact impartial or biased. In that particular case, the panel decided that the judge's comments, and the judge said, I was just trying to make a statement of fact, that one case was more complex than the other. But the court thought that that statement could be interpreted by some people to mean that the judge had already decided one way or the other which way she was going to vote or which way she was going to rule. And that may seem unfair, but that's the way the rule considering impartiality is dealt with. There's another case that I cited from the state of Connecticut, and in that case, a judge had, there was a dispute involving land, and a judge had, with counsel for both sides, gone to check on the disputed parcel of land. Then the judge, on a third occasion, went to the parcel of land without the lawyers. And in that case, excuse me, that case is Abington Limited Partnership versus Hublin, 1998, Supreme Court of Connecticut. In that case, the information came out that the judge went to the property and a third time, and the lawyers weren't there that time. And one of the parties moved that the trial of the action be stopped and the judge be removed from the case because of the appearance of impropriety. And the Supreme Court of Connecticut, again, like the Massachusetts court, made a clear distinction between a claim of appearance of impropriety and actual impropriety. And it said that, again, the appearance of impropriety would reasonably leave one to question the judge's impartiality. The question is not whether the judge is impartial in fact, but whether impartiality might reasonably be questioned. And the court said the correct question is whether the judge's conduct might lead a reasonable person to knowing whether the judge is actually impartial to question his impartiality. The court determined that considering the relevant factors showing in its entirety, they were persuaded that a well-informed, thoughtful, and objective observer could reasonably decide that there was, in that case, a significant risk of judicial impropriety. And in that case, the Connecticut Supreme Court reversed the judgment in the case and remanded the case for a new trial. So,
Mr. McCardle, in Maine, we have a number of our judges who come directly from a prosecutor's office, from a district attorney's office. Those judges immediately start sitting on criminal cases, not in the region where they've been with the district attorney's office, but in another region. taking your analysis, it seems that you would say that that is improper. First of all, is that correct? Do you think that is improper? And second of all, does our reasonable person, our hypothetical reasonable person, understand that that is the way we've worked in Maine for a really long time?
I think where the committee's view is that we're talking about something that is different than just a situation where somebody, for example, is a prosecutor of various crimes, and then they get appointed to the bench, and they end up being a trial judge, being involved in criminal cases. This case is different than that.
In what way?
In this case, we have a Maine Supreme Court judge who took not only represented banks and banking interests, but decided to sit on 2 cases when work he had done on very specific foreclosure matters was about to be re-questioned. And she did that in a period of time that was about 5 years after she was actually involved in those appeals. And one of the cases that she wants to rely upon and stress to this panel, and that was a case that was suggested to the panel, to the ethics panel by Justice Connors, is the Hoke case. And the Hoke case is not the Connors case, even though the ethics panel sort of hung its hat on Hoke to say to Justice Connors, oh, it's okay, you can continue to be involved in these 2 cases. They're significantly different matters. The Ethics Committee was just wrong about that. I'm going to tell you about Hoke right now and why these are really different situations. In the Hoke case, a judge refused to disqualify himself, and because he had an alleged conflict that had occurred when he had practiced law 17 years earlier. In the Hoke case, the facts and the law applied that he was being challenged about applied to only one of the claims for relief in that case. And importantly, the case that he had been involved in 17 years earlier was severed from the underlying case, and the case in the present time did not involve the issue on the present appeal, which is the exact opposite of the Connors situation. The issue in the appeals before Justice Connors were to decide whether the Pushard and Duchesne cases should be overturned. So this case, the Connors case, is a 180-degree from the Hoke case. It's not a generic situation where somebody's a prosecutor, they become a judge, and after a certain period of time, they are involved in prosecutions. Interestingly, the information that I gleaned just from sitting in on a judge's seminar that was given at Sunday River a couple of years ago, which is shortly before I started this position, working for the Committee on Judicial Conduct, the question came up about recusals. And the consensus, and I don't know if any of the members of this panel were at that meeting, but Justice Martinucci was speaking on this topic. And it seemed to me that even in situations where there were situations where prosecutors had become trial judges here in Maine, that recusals were taking place for in the neighborhood of 5 years or more. And again, if any of you were there, you may recall that. I think in this case, the committee thinks in this case, that the idea of recusing for 2 years from foreclosure cases is not significant. Justice Connors would say, well, she did say, not would say, she did say, I recused, in one of the responses to the Committee for Judicial Conduct, she said something to the effect, I I decided that I would recuse myself for 2 years in foreclosure cases, but in effect not longer because I didn't want to burden the court. Well, the reality of it is this. Oftentimes, there's not a full panel of judges on the law court because there are recusals. It just happens. If you look through decisions of the Maine Supreme Judicial Court, you'll see there are decisions where there are 7 judges, 6 judges, 5 judges, even 4 judges. And in this particular, in the Finn case, one of the 2 appeals that Justice Connors decided that she was going to participate in, Chief Justice Stanfield recused herself. It didn't stop the proceeding. It didn't delay the proceeding. Justice Connors could have recused herself. One sentence, I hereby recuse myself in this case. We wouldn't be here today. But she decided that she was going to be involved in those matters. And I'm not saying, and the committee's not saying, that she intentionally said, I'm going to break a rule here. I'm going to do something that breaches the rule regarding the appearance of impropriety. That's not what we're saying at all. But what we are saying is that she had a blind spot. For whatever reason, she had a blind spot to the appearance of impropriety. And when she contacted the Judicial Ethics Committee 3 months after she was involved in the Finch oral argument, she presented the information for them to consider in terms of her past representation of parties and disqualification of a judge based on prior representation of a party. She did not mention the appearance of impropriety. When the Ethics Committee responded to her, they did not mention the appearance of impropriety.
Now, Mr. McCarthy, with respect, on page 2 of her memo to the committee, she says, Rule 2.1 requires recusal in any proceeding in which the judge's impartiality, quote, might reasonably be questioned, which includes, and then she went on to say, which includes when the judge served as a lawyer in the matter in controversy. She included that caveat, that's one of the specific provisions, but she did bring to the attention of the committee the rule that talks about recusal when the impartiality of a judge might reasonably be questioned.
I stand corrected there. There's information that she didn't present to the Ethics Committee that she should have presented to the Judicial Ethics Committee so that she would have gotten a better answer from the Judicial Ethics Committee about proceeding or not. For example, she didn't tell the Judicial Ethics Committee. The Judicial Ethics Committee came to the conclusion that the cases that she was going to deal with on the Finch and Moulton appeals were entirely different than the Duchesne case, and that in fact just was not true. As I said before, and I think it's marked as Exhibit B to Attorney Cox's complaint, the Maine Supreme Court specifically sent notice out in August of the year of the Finch oral argument saying, we want more briefing, we're considering whether or not Pushard and Duchesne should be overturned. That should have been more clear, made clear to the Judicial Ethics Committee. That's exactly the type of information they should know. It also should have been made clear to the Judicial Ethics Committee, and it was not stated, that Attorney Connors still had an interest, a financial interest in the Pierce Atwood firm, and the Pierce Atwood firm was the firm that she worked for 34 years, worked for on behalf of banks, the Maine Bankers Association, specific banks, and that they stood to financially benefit from holdings that would come down in favor of banks if they came down in favor of the banks. And because Justice Connors did not recuse herself, the Finch decision was a 4-3 decision. Had she recused herself, the Finch vote would have been 3-3, and Finch would not have made new law. Finch would not have overturned Pushard or Duchesne. And so the Judicial Ethics Committee, in their informal opinion, did not have, before rendering that, they did not have all of the information that they should have had that should have given them pause to say, you know what? Given all the facts here, it just doesn't look right. We know you participated in the Finch oral argument, but that doesn't look right, and it doesn't look right for you to stay in these cases. And the reality of it is that the Committee on Judicial Conduct, by the time it evaluated the situation, it had much more information than the Judicial Ethics Committee had when it rendered its informal opinion. The Ethics Committee didn't have any of the information about Justice Connor's questioning and representations at the confirmation hearing when she testified about conflicts, recusals, the appearance of conflicts, and what she would do in those situations. So the Judicial Ethics Committee, in its informal opinion, didn't have all the information to really give the best advice to Justice Connors, and that's why she continued to participate in those appeals. We contend that if they had all of the information, they would have come to a different conclusion, because that's what's logical.
Mr. McCardle, in your joint statement of facts, is there anything about Justice Connors having a financial interest in Pierce Atwood?
No, it's not in the joint statement of facts, Your Honor. It is part of the record in this case because it is contained in one of Justice Connors' 2 responses to the Committee on Judicial Conduct, where she said something to the effect of, I still retain a financial interest in Pierce Atwood, albeit a small, and I'm saying that from memory. I don't have that probably word for word, but yes, okay, on page 2 of Justice Connors' letter to me, dated June 7th, 2024, she said, I continue to recuse in any appeal in which Pierce Atwood represents a party or amicus because I retain a financial interest, in quote, in parentheses, albeit a very small, in parentheses, in the firm. And that is on page 2, 3rd paragraph after the heading recusal decision.
But what's your connection, what's the financial interest got to do with Pierce Atwood didn't represent anybody in these
No, it
appeals?
didn't. But she had a financial interest in a law firm that is an affiliate member of the Maine Bankers Association and who represents banks, and they stood to benefit. The bank stood to benefit, and the Bankers Association stood to benefit from the Finch decision if it overturned the prior decisions that Justice Connors had briefed and been involved in and advocated on behalf of the banks and the banking interests. It's part of the picture, Your Honor, that suggests that when you put all of it's one of several facts that when you put them together, it just doesn't look right. It doesn't mean that Justice Connors had bad intent. It doesn't mean Justice Connors was biased. That's not the issue. It looks bad. It looks bad because the facts suggest the question, can this judge be fair? That's a fair question. That is the question. And the fact that a reasonable person could ask that question means there's a violation of the rule.
Isn't that based on an assumption that because an attorney represented a client in a prior proceeding and advocated for a particular result, we're now going to assume that as a judge, that person, that attorney is biased because of the representation that she had in a prior case that's unrelated. I know the issue is the same, but the case is not the same, the client's not the same, the law firm's not the same. Aren't we assuming that, well, it must look bad because she advocated for a client for a different result than she's now voting for as a Supreme Court justice?
Well, I disagree, because the reality of it is that she still had a financial interest in that law firm. And so she stood to benefit by the 2 cases that she had been involved in before as an attorney at that law firm being overturned by the Maine Supreme Judicial Court, on which she was an acting judge that refused to recuse herself. So it's not, again, we don't need to show, and the rule does not require that actual bias be shown. Right. It's just I guess to put in layman's terms or laywomen's terms, this just doesn't look right. And when it just doesn't look right, Rule 2.11A says you have to recuse. Recusal is necessary. Must, you shall or must recuse. There's no discretion there. You have to get out. And one of the cases of the probate lawyer down in York County who got into trouble several times, that case, among other things, stands for the proposition that Rule 2.11A in recusal is not discretionary. It's mandatory. The plain language of the rule, shall recuse. There's no option there. You shall recuse if your impartiality can be questioned.
Well, reasonable.
Not proven to be less than impartial, but just reasonably questioned. So the totality of facts here suggests that Justice Connors, a highly educated person who worked at a very sophisticated law firm, who represented banks and banking interests, who knew that questions of the appearance of impropriety in foreclosure cases and banking cases was raised at her confirmation hearing, knew that there was an oral argument in the Finch case that she was participating in before she sought any advice from the ethics committee. All these things put together suggest that a reasonable person would question whether she was partial or not. Excuse me for a minute.
If you want to reserve some time.
So, Mr. McCardle, so hypothetically, assuming we agreed with you, what are you asking the committee to do?
Thank you for asking that question. The committee is asking that this panel issue a reprimand to Justice Connors. And not for the benefit of the panel, but for the benefit of the people who are listening to this or watching this, don't understand what that means. Really what it means is saying, in other words, you did something wrong, be more sensitive to this issue of the appearance of impropriety or impartiality, and don't do it again.
So can she
That's
never?
what we're asking for.
Is she barred from doing foreclosure cases?
Right now,
Is that
she
what you're
isn't.
saying? She's barred.
Right now, she isn't.
But
No,
that's what
right now,
you're-
she isn't.
But isn't that basically what you're saying is, if it looked bad then, it's going to continue to look bad? And she can never do a foreclosure case because she represented banks when she was in private practice?
Well, I'm not going to say it's that extreme, Your Honor. What I would say is that if the issue comes, if a foreclosure case comes up again, what the judge should do is contact the Ethics Advisory Committee before you do anything on it. If you're going to consider sitting on it, contact them first instead of going and participating in an oral argument. So that's what I'm suggesting. I'm not suggesting, the committee's not suggesting that the door is just closed permanently. But first things first. First you get advice. If you have a question about whether you should do something or not and you're a judge, go to the ethics committee and get the information before you do the thing that you shouldn't potentially be doing. That's not what happened here. So again, no, we're not saying she's absolutely not able to sit on any foreclosure case, but I would think that a lot of judges would say, you know what, I don't think I'll do that. I don't think it looks right, and I think that reasonable people could still say, yeah, she shouldn't be doing this, whether it's
Well, let me give you an
next
example.
week or next month.
You talked about this, the 2-year sort of practice and the 5-year practice, and the presentation at Sunday River, which I assume I was there, but I can't swear to it. I can tell you that, at least as far as I have known, the general practice was to recuse from your private. For example, in my situation, I worked for the Attorney General's office for almost 37 years. 25 of those was in the criminal division. When I went on the bench, I was explicitly told, and this may be where the 2-year rule comes from, I was specifically told, obviously you can't handle homicides that were pending in the office at the time I was there, but I wouldn't be doing homicides at all for 2 years. And then after 2 years, I began doing homicide cases with the Attorney General's office. Now, one could say my association with the Attorney General's office for that length of time doing homicides is going to look bad to some people. Somebody's going to assume, well, of course he's biased or partial in favor of the entity he worked for 37 years.
Well, but the difference, Your Honor, is, among other things, a major difference is when you went to the Attorney General's office, you weren't presumably have a financial interest in a, let's say, criminal defense firm that somehow, based on your involvement, would actually lead to some kind of financial benefit.
I guess I'm wondering about this financial interest, because it's not part of the joint statement of facts.
No, it's
and
not.
I thought we're supposed to base our decision on those facts.
No, Your Honor, I believe that, first of all, this is a de novo review of the case, and the parties have agreed that the panel would consider the facts and the record in this case and the briefing in this case in rendering a decision. So we're not limited solely to the joint statement of agreed to facts. There are other facts that weigh in one way or another that are part of the record. So it is the financial interest is part of the record, and I didn't say it, Justice Connors said it, and Justice Connors said it in her second letter to the committee. So that should be it is part of the record, and it should be something considered by the panel.
But it's still attenuated in the sense that Pierce Atwood was not representing any of the parties in these cases.
That's correct. That's
so
correct.
The hook here is Pierce Atwood is an affiliate member with the Maine Bankers Association. She has a small interest in Pierce Atwood, and therefore, if the Maine Bankers Association, which is an amicus in one of the cases, the Moulton case, I guess, prevails on its argument that she somehow has a financial interest in that, however slight, through that connection to Maine Bankers Association.
It's part of the bigger picture of it looks bad. It looks bad. So some facts look worse than other facts, but that fact is part of the several facts that the committee contend make this situation look bad to a reasonable person knowing all of the facts, and that's just one of the facts. So going back to the sanction question, I mean, obviously there are many different sanctions that can be asked for by a committee concerning the judge. The committee well considers appropriate factors when determining what sanction they suggest. And the sanction sought is not a severe sanction. It's not a suspension. It's not a docking of pay. It is simply, but importantly, language to the effect that the appearance of impropriety is important. And if you're not thinking about it, you should be thinking about it. And you have to be mindful of how reasonable people will perceive your conduct. And in this case, we think it's entirely reasonable, given the totality of circumstances, for this panel to say, and mirroring Justice Connor's own words at her confirmation hearing, and her mirroring Justice McCusick's words that she invoked at her confirmation hearing, and mirroring the judges panel that Justice Lopez sat on in the Massachusetts case, if it's a close call, you recuse. If it's a close call, you recuse. And in this case, the panel doesn't think it was a close call, but even if it is a close call, Justice Connor should have recused. Unless there are more specific questions for me right now, I'm going to sit down and let Attorney Bowie speak and then come back for rebuttal if necessary.
Thank you.
Thank you.
believe I turned it on. Yes. Okay. May it please the court, I'm Jim Bowie, and it is my privilege to be here on behalf of Justice Catherine Connors in this proceeding. I'd like to start by noting 6 undisputed facts or contentions that we believe demonstrate why the report from the committee in this case should be discharged and the allegations of violation as to to Justice Connors should be dismissed. First, and to a certain extent I think Mr. McCardle has acknowledged this, but although Rule 2.11 provides 4 distinct bases for recusal, specific items that require recusal, none of them apply in this case. There is no conflict of interest in this case, either alleged or even suggested in the materials. This is simply, from the committee's standpoint, an allegation that from their standpoint, there could be some question, and I would suggest to you that some question falls far short of reasonable basis for questioning impartiality, but that there is, theirs is that appearance of impropriety is, in this case, required recusal, and it simply doesn't apply for reasons that I will come back to in a moment. Secondly, it is important in the context of this case, particularly for the reason to address some of the issues raised by Mr. McCardle, to note that in this case, there was no motion for recusal. There were 4 parties between the 2 cases, 9 amici, multiple law firms, because sometimes more than one law firm appeared for those parties. There was no motion for recusal. Sophisticated litigants did not see an issue to raise a question as to whether Justice Connors should sit on those cases. The complainant in this case was aware of those cases and did not file any objection, did not seek to intervene, did not seek to file an amicus, did not, even on an informal basis, attempt to raise this issue at any time prior to the decision being rendered in Finch.
Excuse me, Attorney Bowie, would the complainant in this case have any standing on which to raise an objection if he wasn't a party and he wasn't involved in the amicus brief?
First of all, they could certainly have filed a complaint with the committee. That could happen at any time. That's what happened after the fact. There would have been nothing barring the filing of a complaint with the committee well prior to when a complaint was filed. There was also no prohibition from raising either informally or with a question to the court whether a justice should appear. Whether that, it may not appear in the sense of a formal motion to recuse. They may not be standing to do that, but certainly nothing bars a party from raising with the court that question so that the court could address it, so that the individual justice would address it.
Excuse me for interrupting, but isn't it the case that in, when something is pending, the committee would not decide in any event a complaint such as that because of issues of judge shopping until the case was resolved?
I'm not sure that that is true, Your Honor, candidly. And in this case, Mr. Cox certainly, if he had those concerns, could have raised it with the litigants so that they could raise it if they felt it was important. These were, if you look, the parties that are representing the debtors are part of the MASH entity that Mr. Cox is part of as well. Do I know whether he took the opportunity to address those issues with the direct litigants? I do not, but certainly he could have. The third point that I would like to make is that before argument in Moulton, Justice Connors asked for an opinion from the Advisory Committee on Judicial Ethics, and that committee unanimously found no issues. Unanimously, and I'll come back and look at this a little more later, but I would point out that the committee was advised specifically of the interface between Duchesne and Pouchard and Finch and Moulton, and that the issue of whether Duchesne and Pouchard should be overturned was raised specifically in her letter to the committee. Fourth, there is no case in the United States that we were able to find that says that an attorney's participation in litigation, raising an issue, bars that attorney from becoming a judge and dealing with the same legal issues as a judge. None. That issue, we raised that issue in our brief to the committee to suggest whether or not there was such a case. No case has been cited by the committee. And I'd respectfully suggest that's because there is none. There is, on the other hand, to the contrary, a number of cases that say that it is inappropriate to consider prior litigation by a lawyer who then becomes a judge as being disqualifying for that judge to hear the same legal issues that the judge participated or litigated as a lawyer prior to coming onto the bench. Fifth, I think it is important for the court to note, and the rules, including the commentary to Rule 211, note that unless recusal is in fact required, the judge is ethically required to sit and hear matters to which they are assigned. And that rule is of equal force as Rule 2.11 to recuse. And lastly, because some of the suggestion is public clamor, if you will, Rule 2.4 makes clear that the judge may not consider publicity, public clamor, or fear of criticism in making a decision, or which includes a decision whether or not a judge should recuse. I want to start, I want to start, if I may, by just going through Rule 2.11. Rule 2.11 does start, in A, with a judge shall disqualify or recuse him or herself in any proceeding in which the judge's impartiality might reasonably be questioned. And then it goes on to say, including but not limited to the following circumstances. And I would submit that what the rule is trying to do here is to put some parameters, some way of determining what that very broad statement might mean. And when we look through to them, we start with number one, which is the judge has a personal bias or prejudice, or the judge has personal knowledge of facts that are in dispute in the proceeding. That was the issue in the Connecticut case that Mr. McArdle noted. The judge went out and got personal information, which then required recusal. Recusal, therefore, was not mandated because of a generalized question as to whether the judge's impartiality might be reasonably questioned. To the contrary, it was because the judge went out and got personal knowledge, thus violating 2.11A1. The second provision in Rule 2.11A is that a judge knows that, subparagraph 2, the judge knows that the judge, individually or as a fiduciary, the judge's spouse, domestic partner, personal within third degree of relationship, so forth, participates in the case in a variety of ways. In other words, it is a personal basis for recusal on the part of the judge if a relative or someone that they know is participating as a lawyer, participating as a party. What is interesting and I think key there is it goes on to say in C, this is 2.11A to C, is a person who has more than a de minimis interest that could be substantially affected by the proceeding. That's the Maine Bankers Association piece. There is nothing in this record to suggest that there's anything other than, at best, an attenuated basis for that Pierce Atwood, not Justice Connors, but Pierce Atwood might have a de minimis interest if, I suppose, its membership in a group might be helped by a particular ruling. I would also note on the, while we're here, on the financial interest piece, that the committee made no finding with regard to that whatsoever in their findings. It's not in their report. It is not in the statement of material facts here. It has come up in the briefing and today, but there is no basis in what the committee found as facts in its report to the law court, which was an amended report because the law court had pointed out that it had failed the first time to make any findings of fact. Those aren't there. And respectfully, there is no violation by Justice Connors with regard to a financial interest in this case in any way, even as, quote, a factor for what whether her impartiality might be reasonably questioned. Subparagraph 3 of 211A is that the judge, while a judge or judicial candidate has made a public statement other than in a court proceeding, blah, blah, blah. That is the Gertner case. Justice Gertner made a statement publicly while the case was pending. What is interesting and perhaps informative for this case is that you note that the rule specifically says there, the judge, while a judge or a judicial candidate, it does not suggest that the judge, prior to being a judge or a judicial candidate, would be disqualified for making a statement about the issues that might come before the judge down the road. Four is that the judge served as a lawyer in the matter in controversy or associated with a lawyer. We know in this case that in these Finch and Moulton matters, Pierce Atwood was not involved, nor was any client of Justice Connors until the Maine Bankers Association filed an amicus brief in Moulton, which was what triggered her decision to seek an informal guidance from the Judicial Ethics Committee, the advisory committee. Further,
Attorney Bowie,
Yeah.
you know, at that point when Justice Connors became aware that the Maine Bankers Association had filed an amicus brief, and where she had previously filed amicus briefs on behalf of the Maine Bankers Association, shouldn't that have been enough to wave the red flag for her that she really should recuse?
I would suggest not. We have
Yeah.
cited several cases where filing an amicus brief is not disqualifying in subsequent litigation by a judge who filed an amicus brief as an attorney. Hoke is one of those cases, but Hoke cites other cases, and we cited in our briefing additional cases to the effect that filing an amicus brief is not a disqualifying factor.
But Mr. Bowie, excuse me for interrupting again.
Sure.
Isn't the filing of an amicus brief thus representing a party who's filing, representing an entity who's filing an amicus brief, Isn't that something that Justice Connors specifically brought up in her testimony to the Joint Standing Committee? That she recognized that not just representing parties, but representing entities who filed amicus briefs could be grounds for recusal?
And that's why she asked for guidance from the advisory committee raising exactly that issue. And as I said, the case law suggests that that is not a basis for recusal. There is no case citing to the effect that filing an amicus brief is a sufficient interest as opposed to filing or participating or filing a brief for a party that then continues to be a party in the litigation before the judge.
Let me ask you though, Mr. Bowie, that may get to the technical point that it's not a disqualification, but what do you say to the point of the committee that it looks bad? Just creates the appearance that you are now sitting on a case in which a party, not a party, but a participant, I guess I'll call it participant, amicus, has now weighed in, presumably advocating a position similar to the position you as a lawyer advocated for them 5 years earlier, but it just looks bad. It creates the impression to, Mr. Average Citizen that, well, it's sort of a done deal. You assume that she will rule a certain way because it looks bad.
And I guess I don't think you can distinguish that from representing a party or who has raised exactly the issue that is now before you as a judge. I mean, it's still the same situation, and that is not disqualifying. In fact, as I said, there is no case in the United States that we have been able to find, and certainly none that the committee has cited, that requires a judge to disqualify him or herself from a legal issue simply because they litigated that identical issue as a lawyer. And that's what this case comes down to. Is Justice Connors disqualified from sitting as a judge on the law court dealing with Deschênes, a possibility of overruling Deschênes and Pouchard? And the bottom line is that there's no case in the United States that says that's disqualifying. And those cases address 2.11. The bottom line, to sort of go back to some of the questioning that started before, is that judges throughout the United States, but certainly in a smaller state such as Maine, have lives usually as lawyers before they become judges. And they participate in any number of cases. That is expected. It is known, including by the reasonable man, the man on the street. They understand that in order to become a judge, you had to have experience in the law, and you get that experience in the law usually by representing people in cases. And that's entirely appropriate. It's expected. As a result, the case law treats a question of a personal involvement by the judge, which is disqualifying, very differently from the fact that the judge represented a party dealing with an issue which is that is issue-based, because that's what lawyers do. As one of the cases, the Obert case that I've cited, says, neither litigants nor lawyers are entitled to have judges come in who are tabula rasa. I mean, you come back, judges come in with a background. They have knowledge, they have experience, and that's okay. It is not disqualifying.
I know I don't mean to interrupt your train of thought, but can you address the committee's concern over statements that Justice Connors made during a confirmation hearing, which seems to play be a factor in the committee's report? that she made representations.
Actually, it's
and they
not in the
expressed
report. It's in the briefing. It's not in the report, interestingly. Not the amended report. But in that, Justice Connors was pressed on generally how she would deal with cases where she had had some involvement. There was Representative Hartnett pushed on tribal issues, and Representative Evangelist raised the issue with regard to foreclosures. And she was pretty precise, given what was sort of a ambiguous back and forth, and it bounced from one issue to another, as I'm sure all of you may recall from your own experiences before the committee. And in it, she said that she anticipated there would be substantial recusals from foreclosure cases because she would recuse from any party that she had represented or any case where Pierce Atwood was the attorney. And those are a large number of the foreclosure cases that come up, would involve a party that she represented or Pierce Atwood. There is nothing in her testimony, and if there's any question, I'd ask that you go back and review it carefully. She does not say that there would be a blanket recusal from foreclosure cases. There would be significant recusals in foreclosure cases if they involved parties that she had represented or Pierce Atwood.
Mr. Bowie, let's say the timing had been a little bit different and Justice Connors filed her brief in Pushard, and by the time it was argued, we're already sitting on the Maine Supreme Court. Could she have participated in ruling on that case as a justice?
No, because she participated in the specific case that was before her.
Right. And so why was it appropriate after the discussion turned to whether Pushard should be overruled for her to sit on it then?
Because Pushard, at that point, the cases that were before her were not Pushard and were not Deschênes. She could sit on that, just as Justice Horton, who wrote the decision, I can't remember whether it was in Pushard or Deschênes, but wrote the decision that was overruled by the law court, then was not prohibited from continuing to sit on the Finch case and in fact write the decision. It is difficult substantively to distinguish a judge who writes a decision going one way, gets overruled in a case, and then is asked, because they have been elevated to another court, to sit on an appeal and basically overrule the earlier decision and reinstate the rule for which that judge advocated, from the position of a lawyer who simply advocated a position for a client as a litigant in prior litigation. And I would like to, before we go further, I think it is important for the court to remember that just because a lawyer advocates a position for a client doesn't mean that that's the lawyer's position. Speaking as someone who had early in his career the misfortune of representing a number of litigants for things such as foreign object cases and medical malpractice, for advocating for the continuation of interspousal immunity and interfamily immunity. I lost all those cases. It doesn't mean that if I had been sitting as a judge, I would have ruled necessarily differently than the law court ultimately did in not seeing the wisdom of my contentions for maintaining those doctrines. So that's another reason why the mere fact that a lawyer advocates for a position as a lawyer for a litigant is not then precluded from addressing those issues as a judge. That the judge has to make the decision, as in any other case, as to whether the judge feels that they can be impartial in deciding the case going forward.
In assessing the sort of the average person who's looking at this, and who I guess is the standard we have to go by, and whether that average person questions the impartiality and whether that questioning is reasonable, does it matter that the issue in controversy is one of public concern, like foreclosure of residential mortgages? That this generated a lot of, the issue of foreclosure, mortgage foreclosures, generated a significant, I guess, buzz, I don't know how else to say it, in the legal community, among the bench and bar. It affected, many homeowners who had mortgages, et cetera. Does that, if this were an insignificant sort of esoteric issue of law, that, maybe inside baseball, does that make a difference?
No. Rule 2.4 says it can't make a difference. Public clamor, publicity, whatever, can't be a factor in how a judge determines a case, including the decisions as to whether to sit. We have a litany of cases, starting with Laird and going forward, explaining why judges who are involved in high-profile matters, civil rights cases, for example, criminal justice cases, and so forth, may take positions that have a fair amount of public interest, if you will, as attorneys. That does not mean they are subsequently prohibited from addressing those issues when they become a judge. In fact, in many ways, that's the reason people got appointed to the bench in the first place. They'd established a reputation in particular areas of the law. And the assumption is that these people are knowledgeable, they are professional, they have demonstrated the ability to deal appropriately with legal issues, and that they will do so fairly and impartially as a judge. But it doesn't mean that they can ignore or forget everything that went on before they were able to put on a robe. Because we're, I think we've talked generally about this issue of reasonable person, but I would like to bring it back that the question here is what Justice Connors should or shouldn't have done in this case from her perspective. And the fact that there is no recusal is important here. The reason that courts are chary, and that the reason that the comments to Rule 2.11 raise the issue of being very cautious if someone raises a question of whether a judge should have recused after the decision as opposed to before, goes far beyond simply not having litigants have the ability to have a heads I win, tails you lose type approach to a case. It's because requiring a recusal or a motion for recusal or having an objection brings the issue of whether there is a basis for recusal to everyone's attention in a well-crystallized, well-articulated way.
But Mr. Bowie, isn't it correct, though, that your argument that there was no motion to recuse is wiped away, back-burnered by your argument that Justice Connors sought the Judicial Advisory Committee's opinion on her ethical dilemma? Did that cause him wasn't that her occasion to solemnly consider, to have that focused inquiry into whether or not she should have recused?
Well, no, not in the same way. You know, one of the issues that Mr. McCardle raised here was whether she was complete in articulating what the issue was. And remember, this is from the standpoint of the judge who's saying, okay, this is a foreclosure case. I think I should be hearing foreclosure cases now, but what's triggering this is that I did have, or I had filed an amicus brief, not representing a party, but an amicus brief in a case, and how does that work? And she raised that specifically in her letter to the advisory committee. She raised specifically that I filed an amicus brief, they're now in this case, and by the way, the court is specifically going to address, as she says, should the court reconsider and repudiate the language in Federal National Mortgage Association v. Duchesne and Pouchard v. Bank of America, N.A. And so she's raising this. That's different from what would be raised, I think, as a litigant who is saying, I don't think you should sit. I don't think you should sit, and here are the reasons, as someone apart from you, so somebody looking at it from an entirely different perspective and raising the issue in a way of, these are all of the things that I think you should be considering, Judge. That's a process that is very helpful, I think, for a judge in being able to address whether or not recusal is appropriate. You're not relying on the judge in his or her own head to try to figure out, okay, what are all the things that people are going to think about? You get a chance for the people that are going to contest that decision to make the case more precisely, more clearly than you do in that sort of insular part from a judge. That's why the committee notes to Rule 2.11 make clear that a judge may, not shall, may recuse if they feel there's a potential for impropriety, if they feel that it is, in fact, sufficient to cause recusal, but shall if there's a motion. That rule cites in a footnote to the comments Judge McKeon from the Ninth Circuit's article, which surveys when recusal is appropriate. And if you go to Judge McKeon's article, Judge McKeon made the point that nor can a judge be faulted for failing to recuse where there is no conflict, and there's no conflict in this case. There's a question of whether there is a appearance of impropriety, but there is no conflict. And her rule is, nor can a judge be faulted for failing to recuse where there is no conflict and a motion requesting disqualification has never been filed. And that's cited by in our commentary to our Rule 2.11. And the reason for that is because you don't get to second guess a judge down the road when no one in the case is raising an issue either. The judge, in this case, Justice Connors went further than the parties who are directly involved in this case were willing to go in raising the question and saying, hey, look, I think this case may be close, but I would suggest that, you have to make a decision one way or the other. This may be close, give me some guidance. And she went to the committee, she got the guidance, and the guidance was unanimously, no violation, you need not recuse. The committee actually precisely phrased the issue as it is phrased for this proceeding, which is that, the sole justifications for recusal would be either that, one, the legal issues raised in these cases are ones in which Justice Connor advocated a position representing a private client. That's exactly what the committee is advocating for here, and the committee specifically found that was not disqualifying because the parties were different and Pierce Atwood was not involved. Otherwise, otherwise you're saying that, civil rights lawyers can't hear civil rights cases. Prosecutors shouldn't be hearing criminal cases. Criminal defense lawyers shouldn't be hearing criminal defense cases. If I assume that if you're a officer in the Maine Trial Lawyers Association, you shouldn't be advocating, you shouldn't be, if you're appointed to the bench, deciding civil justice cases in the terms of civil litigation. It's just way overbroad, and the reasonable person standard incorporates that understanding that lawyers represent parties as lawyers. That doesn't disqualify them from hearing all sorts of cases as if they are appointed to the bench. It would seem to me that if it was as simple as the committee is stating, there should be some case in all of the 50 United States that has found that litigating an issue, appearing as a lawyer in civil litigation, or actually any litigation, appearing as a lawyer and advocating for a particular result, and then being appointed to the bench and dealing with exactly the same issue again, is disqualifying. And that isn't what happened. There is no such case. None. I'd be remiss if I didn't just note that there is a duty, no question that if a judge should recuse, they should recuse. But equally important is that if the judge should not recuse, or isn't required to recuse, they shouldn't recuse. Simply suggesting that someone might second guess their decision is not a basis for having a judge recuse from dealing with tough issues.
I take it, Mr. Bowie, that you agree that one could, under these circumstances, one could raise the question as to whether Justice Connor's impartiality was intact. And I take it that's borne out by the fact that she actually sought guidance from the committee. I mean, she had a question. But does this case come really down to the whole question of, or the whole issue of, is it reasonable to question her impartiality on these?
Well, I guess the question then becomes...
Does it appear, the whole thing that, in a nutshell, what Mr. McCardle has said, what the committee has said is, it looks bad.
I understand that the allegation can be that it looks bad, but it looks bad in each of those cases that we have cited, and there are a bunch, there's a dozen of them in the brief, where lawyers are now being challenged, judges are now being challenged for sitting on cases where they litigated the issues as lawyers. And unanimously, they find that's not a problem. The fact that you get into a very circular analysis if you say, well, if you ask a question, then there must be a question, so therefore you must recuse. That would sort of suggest that there's no reason to have the advisory committee in the
If you have to
the
ask
idea
the-
would
if
be,
you have
if
to
you
ask
went to
the
the
question-
advisory committee, you should recuse.
Yeah, if you have to ask the question in the first place, then you have to recuse.
And clearly, that's not what is anticipated by having the advisory committee. It is to encourage judges to be able to go to the advisory committee and explore concerns with the idea that it may well be that the Rule 2.7 obligation to sit does apply, that you should sit on the case because there is no specific reason to recuse. Otherwise, the first couple sentences in 2.11a swallow the rest of the rule. I would suggest that the reason that the rule then goes on to have a variety of fairly specific indications of, and these are the areas where your impartiality might be reasonably questioned, if you've got a relative involved, if you've made a public statement, if you have personal knowledge, is to show that it isn't as simple as simply saying, well, can somebody raise a question? You can always raise a question. To go back to Justice Stokes' question with regard to prior work in the AG's office in handling murder cases. Sure, I mean, if I'm a murdered defendant, I might well say, Justice Stokes shouldn't hear this case because he did a bunch of murder cases and he's obviously got a point of view, and I'm a murder defendant. I don't want him to hear it. That didn't mean that it would be appropriate for you to recuse forever or at all. The bottom line is that a judge has to be given a fair amount of discretion to be able to make this sort of call and determine whether the judge can sit impartially. And the mere fact that the judge had a prior life that might inform, from some people's standpoints, the issues that they're being called upon to resolve as a judge, that's entirely appropriate. They make that call, and as long as they feel they can be impartial, that is entitled to a fair amount of weight. In this case, Justice Connors did act entirely appropriately. Faced with an issue, she went to the committee and she got a decision, a unanimous decision, saying that she need not recuse. Certainly under those circumstances, and the fact that she did not have a conflict, that she did not represent, that none of the parties before her were not the same parties that she had represented, that Pierce Atwood was not involved, she is entitled to have made that decision. She made it appropriately and professionally, and she did not violate Rule 2.11. As a result, the report should be discharged, and any allegations of violation should be dismissed. I'd be happy to answer further questions. I would just say,
Oh, go ahead.
certainly a reprimand is not appropriate in this case. If you look at the sanctions, that's several steps down the road for standard sanctions if you look at the guidelines. Justice Connors, in this case, I feel made the appropriate decision. Certainly, it was a legally based decision, but she should certainly not be subject to a reprimand. It does raise the issue that Justice Stokes raised before. What does that mean going forward? Does that mean that she cannot hear foreclosure cases? If another judge with a background in foreclosure cases comes forward, they shouldn't hear foreclosure cases? Justice Horton should not have should not have sat on Finch because he had written the decision and therefore made a an argument very similar to Justice Connors as a judge that was overruled and then subsequently came back. Should he have decided that his sitting could have been reasonably challenged by the average person as having pre-decided the case?
Could you spell that out for, I want to make sure I understand, Mr. Bowie, Justice Horton as a justice of the law court wrote, or on the Superior Court? That's what I want to understand.
When he was on the Superior Court.
On the Superior Court, thank you.
Yeah, and I can't remember whether it was DeShane or Pouchard.
Fair enough, but I just wanted to be
can't-
clear which
But
if he had switched hats
he
or...
made he exactly. He ruled in that case. He was overruled by the law court. And then in a very similar position to what Justice Connors was in, is being asked to address exactly the same issues in Finch and Moulton. And no one suggests that it was inappropriate for him to sit, and in fact, he did so sit, and wrote the decision in Finch.
But Mr. Bowie, is that part of our record? Do we know if anybody said anything about Justice Horton or two judges?
No, I'm not suggesting that there is. I don't think there is. I'm suggesting there is no question. It's entirely appropriate.
But you said a couple times now that nobody has challenged Justice Horton, and I don't think that's part of our record, our joint facts or our record.
Certainly, we have the dockets in the Finch and the
Well, it was the Pouchard case that he sat, that he was the Superior Court Justice, and that is part of our record on
Yeah.
tab 5. but-
Yeah. And exactly, and as I said, the dockets for both Moulton and Finch are in the record. And you will see that there is no motion, there is no challenge in those cases. And
As
certainly,
in this case, no motion that she recused.
right. Thank you.
Thank you.
Thank you, Mr. Bowie. Mr. McCarter?
I'll be brief. I have to be. All right, I'll try to cover several points quickly. First one is Rule 2.11a. The language at the beginning of the rule is clear that it includes but is not limited to the following circumstances. The plain meaning of that language is what falls below it are examples of conduct where disqualification or recusal is appropriate, or at least appropriate to consider, but it's not limited to those particular circumstances.
On that point, Mr. McCarter, there's a principle of, I guess, statutory construction. I hope I'm pronouncing this correct, called justum generis. And what it says is that if there's a description in the statute and gives examples that are not exclusive, as this does, Rule 2.11a, gives you a list of examples of things that are prohibited, but it's not exclusive, and it's not exhaustive, then that principle of construction is that it is like those things. It may not be precisely like that, but those examples give you a guideline as to that they're similar to those things that are listed. And I guess my question is, under the committee's interpretation of it looks bad, I mean, that goes so broad beyond what the four examples are, however many there are, and I don't have the rule book in front of me, that as Mr. Bowie said, could it literally swallow up the rule? So that the four examples don't really have any meaning.
Well, the four examples have meaning as four examples of situations, but the language including but not limited to means that that's not the four corners of the examples are not the four corners of the rule.
But it's like that.
And not necessarily. The issue is whether the conduct raises the question of impartiality. That is the fundamental question. Without getting into specifics, that is the fundamental and general question. And then you have to look at the facts. And I'm not going to repeat the facts here that I stated at the beginning of my argument, but the committee contends that the type of conduct that occurred here falls within the rule and is sanctionable. On Mr. Bowie's point.
Are you not arguing that some of the factors that you asked us to consider, are you arguing they do not fall within the four specifics?
Well, the question of reasonable impartiality tying to example number one, if the judge has a personal bias or prejudice concerning a party or a party's lawyer, or the judge has personal knowledge of facts that are in dispute, I suppose an argument could be made that, well, Justice Connor's past conduct raises the issue of impartiality because there's a question of bias. But what we're saying, I'm trying to stick to, and the committee's trying to stick to, the language of the rule here. And the fact that this is the first case again of this type against a Maine Supreme Court justice is not to be construed that because of that it doesn't fall within this catch-all provision which allows for different factual scenarios to be considered as potentially violative of 2.11a. This is a situation where the facts are fairly extreme. And as one or more of you have stated, and maybe Mr. Bowie did, well, I'm not going to say what Mr. Bowie said, but if the situation is a close call, you recuse. Judge McCusick says it. The panel with Judge Lopez, Justice Lopez says it. And to quote one of Justice Connor's former law partners, who's now deceased, Mal Lyons, when speaking at an ethics seminar around 2012, he said, if you have to think about whether you should do something or not, you probably shouldn't do it. And in this case, it's a little different because Justice Connors didn't think about what she should be thinking about before she did it. She got into the Finch case, participated in the oral argument, and she didn't get outside advice and just forged ahead. 3 months go by. Then the brief prompts her.
I know you've emphasized that she was in the Finch case 3 months before the Moulton amicus business came up. What was the basis for her to recuse? That she had litigated the issue 5 years earlier? But there's no case to support that. There's no body of law that says she had to get out, other than, well, the assumption or the presumption that because she litigated an issue as a private practitioner, she now must recuse. She must be biased. It appears she may not be, but it looks like she might be. I mean, that's really the argument that the committee's advancing.
Well, there's again, to emphasize, there's a big difference between the judge actually being biased and somebody questioning whether she could be biased. And that's the hurdle, or what the committee says that we've shown, that a reasonable person would say, given all of the facts that are out there, and on that point, in terms of what Mr. Bowie said, because I thought it was a little murky, on what is part of the findings of fact in terms of what happened at that judicial confirmation hearing, paragraph 4, which runs for about 1.33 pages in the amended report to the Supreme Judicial Court, has word-for-word exchanges between Justice Connors and members of that committee on the topics of recusal and the appearance of impropriety. And I just want to make that really clear because it's there in black and white. It's in our report, and I didn't want any confusion about that. I just want to make one or two more points before wrapping it up. I mean, every sitting judge has a past as an attorney, and they've worked on various cases. Sure, nobody's disputing that. The committee's not saying, oh, if you have experience, you can't be a judge. No, quite the opposite. But that's not carte blanche for doing whatever you want as a judge. The rules apply to judges. And for a Maine Supreme Court judge, the rules apply all the more so. Members of the judiciary in general are held to the highest standards of accountability. The Committee on Judicial Conduct has never brought a claim against a Maine Supreme Court judge before. We don't think of these matters frivolously. This isn't a joke. This is something that involved foreclosure cases, and unfortunately, the law changed, and a lot of people are going to be hurt by that. And the law wouldn't have changed if Justice Connors didn't sit on the case. The law would have remained the same because it would have been a tie 3-3. So to wrap it up, this is a very serious issue. I can tell by the questions both posed to me and Attorney Bowie that you folks have already seriously looked at the issues and the facts, and you've asked very good questions. And on behalf of the panel, I respectfully request that a reprimand be issued, that it's an appropriate sanction, and that it will help in a time where people are questioning institutions, including the integrity of the government and the courts, that this will help keep the integrity in the judicial system in Maine and serve to help with public confidence in our institution. Thank you.
All right.
Thank you very much.
Thank you both very much. We appreciate your arguments, and we will certainly seriously consider all of the arguments. Thank you.
All right.